Welcome to the National Credit Awareness and Resolution Association podcast at NACARA.org, your source for navigating debt repayment challenges during tough economic times. Today we'll explore how small business owners can more effectively use Creditor Tools. Specifically, foreclosure. NACARA aims to bridge the gap between debtors and creditors as a paradigm shift allows debtors to prepare their own repayment solutions. Let's get started. Foreclosure occurs when the underlying collateral is liquidated due to there being an event of default on a loan. The collateral serves as a secondary repayment source, and when there's a default, there's a legal foreclosure process which a creditor can pursue to help satisfy repayment of a defaulted debt. With real estate collateral in a deed of trust state, there will be a recorded mortgage or deed of trust, giving the trustee thereunder the right to take title to the real property at a non-judicial foreclosure or trustee's sale. Other states may require a judicial action, like a court proceeding, which is very expensive and time-consuming in order to recover the collateral. Foreclosure on a commercial real estate property or a single-family residence would indicate that there are no other options left to the creditor to satisfy debt repayment. Of course, prior to the trustee's sale, the debtor will be given a prescribed amount of time to redeem the real property. In other words, payment in full, like 90 days. Then, if not paid off, the property will be noticed up for a public sale or auction within 30 days. What about getting to that appraisal bid? It's possible during this time that a bankruptcy petition could be filed to stay the foreclosure process until the bankruptcy court authorizes the legal action at a future date. Once the bankruptcy court has abandoned the real property, the creditor will pick up where he's left off and proceed with the foreclosure process. After the collateral property is noticed up for a trustee's sale on a specific date, the real property will be sold at a public auction to the highest bidder, possibly on the steps of the courthouse. When it's public, it's public. The trustee will then read the trustee's sale, in other words, all the foreclosure action, and then open to the public a live bidding process to purchase the real property, sold as is, to the highest bidder. The creditor will likely credit bid or be prepared to place a credit bid, an amount equal to the full outstanding balance owed on the loan, including all the unpaid interest, legal fees and costs, and so forth. It depends on how much equity there is, right? However, the credit bid amount will not likely exceed the current appraised fair market value of the collateral property, less the estimated cost to sell it. And that's called the net realizable value. The value that you're going to realize after you take out all the disposal costs. Okay, and that's going to be based on current information obtained by the creditor. Obviously, though, before the creditor bids on a property, the determination will have been made as to any potential environmental risk associated with the property, as the creditor does not want to inherit any potential environmental liability. Whomever the highest bidder is will immediately owe, in other words, like the same day, the trustee, the purchase price in certified funds. So this assumes that somebody else is going to buy a credit bid of the property. If someone else bids higher than the creditor's bid, the purchase funds, less costs and fees, will ultimately be forwarded to the creditor to help satisfy the underlying debt. If no one outbids the creditor's bid, then the creditor will own the property for the amount of the bid, and that amount will be credited against the outstanding balance on the loan. And there's no longer a loan there, right? Okay, the real estate loan, it's gone. It will have been paid, depending on the amount bid, and it's capped at, of course, at the current appraised fair market value of the property, equal to the amount of the creditor's bid and the remaining charged down balance. Real estate collateral will become other real estate owned, or OREO, by the creditor. The creditor will now have another asset on its books, but no longer the original underlying loan. The loan's gone. That asset is now called other real estate owned. If there's a deficiency balance after the amount bid at the trustee sale, and depending on the state in which the property is located and the rules they have to follow, the creditor may or may not be able to seek a deficiency judgment of any unpaid amount on the original loan. The creditor will need to decide if it's even worth trying to collect on any deficiency or unpaid balance. Creditors usually don't spend good or new money after bad money or money it can't collect. The OREO will be valued on the books at the appraised as-is current market value of the real property, less the cost to sell it. Let's talk about personal property collateral, and how that will be liquidated. Regarding personal property collateral like equipment or inventory, once the creditor sues the debtor and possession is granted to the creditor will arrange to have a sheriff sale of the collateral. A sheriff, literally, will arrive at an appointed hour and similarly conduct a public sale of the collateral. Usually the creditor will credit bid its unpaid balance or current market value of that property, take possession of the collateral, and proceed to arrange for it to be privately sold. One way a collateral can dispose of fixed assets, including like inventory, is to arrange for competitors to come and place private bids to purchase the same, usually in bulk. Of course, this is after the sheriff sale has taken place, and assuming the creditor was the high bidder and took possession of it. So he'll gather all the major competitors to come in and do a bulk bid for everything. The creditor may expect that the prospective buyers will bid amounts that are materially discounted. Why is that? The buyers know the creditors must sell the personal property, as the fixed assets are not part of a creditor's business, right? But are assets that effectively must be sold. Such property is only worth what people will pay for it. That said, market bids basically are still market bids, even if they're lower. The bids to purchase the property will likely, like I said, be lower than expected when the creditor may feel it is being held hostage. But market bids are still market bids. It goes to the highest bidder. And if all the bidders are bidding low, that's the way it goes. Keep in mind the standard is to have a commercially reasonable sale. If the right conditions are not present, the creditor can sell it another day. Also, depending on the volume of the personal property, a creditor may have to hire another firm or professional who specializes in selling such assets at the highest price possible. On occasion, depending on the volume, creditors may want to place the inventory in the services of a professional auctioneer company who will arrange a public auction. Those are fascinating. So why is all of this important to you? Foreclosure, for example. First, liquidation of collateral is a big, very big deal. But what's the real cost? By the time your borrowing relationship has reached this point, all sorts of feelings will be happening, right? After all, your business is now being liquidated through the sale of its assets. Maybe you've sunk your life's fortune into it. Maybe you've fought hard to keep the assets in this life-changing event that you're experiencing. That said, debtors have been known to try too hard to hang on to it, even at the expense of their spouses and families. I want to talk about this for a few minutes because of a lot of experience I've had over the years. Okay? Is there not a time and place to let it go before you lose out on family relationships due to the enormous stresses that come? If you are worried about the toll of a forced liquidation that it's taking on you and your family, assuming you have one, take the needed time to really think this through, as only you can make that decision. Look at this through the lenses of an outsider. Collateral, whether it's real estate or even personal property, really in the end, it's just dirt, right? Glass, rubber, metal, etc. Is the stress from trying to hold on to that more important than one's family? Maybe you're thinking that you have to fight for what is right at any cost, right? There's certainly merit there, of course. But maybe you must draw the line and as a family determine what's in the best interest of the family. Take that consensus and run with it. Hopefully, however, not everyone in the family with such a voice are willing to sacrifice themselves too to win the battle with the creditor, right? To the extent that the creditor has a legal path to recover the proceeds for liquidated collateral, why would he stop? He likely has more resources to win the battle than you do, right? This short ad is sponsored by the Debt Crisis Problem Podcast. Attention, listeners. Please join us at tunabudget.com to tune into the Debt Crisis Problem Podcast, where in plain English we discuss the 20 risks that could soon fuel a serious economic downturn. We explore these critical risks and offer practical insights for navigating financial uncertainty. Join us for thought-provoking discussions that encourage transparency and awareness. Subscribe now to stay informed and ready for whatever comes next. So let's talk about this further. A forced or a cooperative liquidation. Assuming the days of negotiating repayment are long gone and you're facing a collateral liquidation scenario, you have a choice to make. You can do it cooperatively or not. A cooperative self-liquidation can involve an orderly disposition of assets using a liquidation budget, where certain costs are identified to cover the entire process over time. In rare cases, it is possible the creditor will help compensate to cover liquidation costs if those cash flow resources are exhausted. In such a liquidation, the creditor will want to help so that the maximum recovery can be realized. While it's possible the market will perceive a distressed seller, you, it is still much better than what the market will pay to a creditor that has to dispose of the collateral. After all, who else knows the collateral as well as you? Who knows the accounts receivable better than you? As you consider a potential liquidation, look at these strategies and pull them in as part of your negotiating process in repaying your loans. Can you see why it's important to build and develop a strong creditor-debtor relationship on integrity, trust, and goodwill? Speaking of the collateral during a workout process, you need to stay with it, safeguard it from theft and loss, even if you know the proceeds from its sale will be going not to you, but to the creditor to satisfy your debt. Don't just dump it in the creditor's lap and walk away. Be instrumental in finding the right buyers who will pay the highest prices and in the most reasonable amount of time. Make the best of a bad situation, right? Next, making the best of that bad situation. As for not being cooperative, you could choose to be quite deceptive and hurt the creditor. Yeah, you can. But you do have a choice here. And hopefully that's not you and your decision. As the recovery or liquidation process heats up, especially when negotiations have failed, you could easily take the attitude that you will do everything you can to hurt the creditor's prospect of being repaid. You may even want to cause as much financial pain on the creditor as possible. This should never happen or be the case, regardless of what may have transpired between you and the creditor. Never. Why is that? Because when the dust settles, and surely it will someday, you do not want to look back and see that you intentionally caused a creditor to whom you owed money to incur more loss than was necessary. You do not want to look back and recall where you were deceptive, even if the creditor didn't pursue legal action against you. Next, don't be deceptive, even if you're angry with the creditor. For example, if the creditor wanted to force the collection of all your accounts receivable, suppose you know that the creditor is ready to send each account debtor a notice to immediately pay the creditor directly and not you. But 48 hours before you expected the creditor would send the notices, you contacted all of them and offered a 15% discount if they paid you right now. Then the next day the creditor tries to collect the receivables, and there are none. All the receivables, those that are collectible anyway, would have been wired to you the day before. This would be a clear and dishonest violation of the loan covenants you signed on to at loan origination. That is deception, and deception's wrong. The creditor will have to launch a bitter defense of its interest with new monies that you caused them to incur, for which you're also responsible to pay. Another example might be where the creditor was preparing to go in and take possession of your inventory. But when the creditor arrived to the warehouse, it discovers that you basically cleared out all the good inventory and hid it in other locations before the creditor could take possession. This would be another clear violation of your loan covenants, and the list goes on and on. Next, there's a better way to resolve any dispute. From the beginning, go all in with good faith efforts. If you screwed up somewhere along the way, even now, and you have poor relations with a creditor, stop. Go back in and fix it. Maybe lay down some cards and seek a quick solution or remedy, and stop the fighting if necessary. You don't want to ruin your personal and family life over material objects or dirt. This contention, anger, deception are not the right course to take. They will gladly follow you right back into your own home each night. All these things will follow you. Your family, your spouse will pick up on the vibes from the moment you pull in the driveway or get out of the car. You can always start up another business someday, okay? And if you're not careful and end up losing your most precious family, you can't get your family back. Don't ruin your life over collateral. It's just not worth it. Period. It never will be either. Ever. Do what you can to assist the creditor to dispose of their collateral and move on with your life. Do it in a way that you and the creditor could both go out and have lunch together after it was all over, even if that may not be realistically happen. Thank you for joining us. Today we covered the creditor tool Foreclosure as debtors prepare to propose their own repayment solutions. We want to hear from you. Share your own credit risk memo and debt repayment experiences, questions, and recommendations with us at nicara.org. If you found today's episode helpful, please subscribe for notifications of future podcasts. Your feedback helps small businesses stay in business. Until next time, step forward and take responsibility for your own debt repayment solutions. Thanks again.